Have you heard about the parole in place lawsuit and how it's going back and forth? Well, let's explain it for you in this video. So watch all the way until the end. All right, y'all. So here you may have heard that there was an order by the Fifth Circuit of Court of Appeals that came out October 4th, 2024, just a few days ago. Finally had a chance to record about this and share with you the insights. So here we go. May I create a presentation and let's go here. So we're going to cover the current status. We're also going to cover the alternate strategy in the meantime, and then also JT's thoughts. And of course, I can't end the video without sharing some success stories. So let's get to it about this current status and what the order showed. And that was essentially it affirms the Eastern District Texas denial of the 11 families joining the lawsuit because they had originally filed a motion to intervene into the lawsuit, the parole in place lawsuit, to be included, right? And it would have been better for them, I think, for them to be included because they can share their story and why the parole in place should still be implemented and continue. Now, other things here is a trial will begin November 5th, and the stay will be extended until November 8th. So, if you're wondering what the stay means, essentially it means that no application of the parole in place can be approved. However, that you can still apply for a parole in place. Now, of course, that's a strategy call that you should discuss with your attorney one-on-one, whether you should still apply for it or not. And I'll share my thoughts towards the end of this video. All right, so now let me share with you the actual order because it's very important to understand it, right? So let me share my screen again. Okay, so here it is, the United States Court of Appeals in the Fifth Circuit, and you can see the date here, October 4th. I don't believe it has a timestamp here. So you scroll down, there's actually not much here. So it says, in a well-reasoned and comprehensive opinion and order by the district court denied the intervention on September 3rd. Wow, that seems so simple. Let's see, what else did this Fifth Circuit said? In this expedited appeal, this court received full briefing on the question of intervention and administratively stayed proceedings in the district court awaiting oral argument on the expedited appeal. We directed that the stay issued by the district court would remain in effect pending further order of this court. Okay, so the stay continues. No one, USCIS cannot approve or deny any PIP application. Further along, it states in the third and basically last paragraph, we have reviewed the extensive briefing, the record, and the applicable law. There is no reversible error or the need for oral argument. That's unfortunate. I would have appreciated hearing some oral arguments on this matter, but they did not allow it. The order denying intervention is affirmed, aka they agree with the lower court at the Eastern District of Texas. The denial of intervention it was without prejudice. Well, it also says here, but we also note that the district court has the option in its own discretion to actually essentially allow these 11 families to participate as amici curiae in any further proceedings. So the court's stay order, the Eastern District on September 11th is vacated. Then you'll learn more on the subsequent order from the Eastern District. But back to the denial of intervention was without prejudice. Essentially, that means that if the 11 families or other families want to, well, these 11 families want to file the motion again, then they can. But likely not in this situation, especially when there's not much here. There's not much in this order. It's only just a few, like 3 or 4 paragraphs. So there's not much to it. And it's very unfortunate because I'm sure these 11 families plus hundreds of thousands of families want to learn more. But they say, hey, they're essentially relying on the order from this district court in Eastern District of Texas. Okay. So the next thing you know is, well, what happened right after that? Okay. So here is the order from the Eastern District of Texas on the same day, October 4th. It's as if they knew that one court that the Fifth Circuit knew. I mean, that the Eastern District judge um, knew that the Court of Appeals was going to order, that Judge Barker would know that that was going to happen, because this one's actually a bit extensive. To some extent, it's I'm sure it's boilerplate, but this is an expedited scheduling order. Okay, this is essentially a scheduling order, and so you can see here that there is a continued stay on this one. Okay, so skipping along to the actual relevant dates here. Now I know that a lot of y'all are concerned about certain dates, which date matters to you. Most of these dates don't matter to you, but it's important for you to know because I'm sure you want to be updated. So take a look here. It says the parties are ordered to immediately meet and confer and reach all necessary agreements to complete discovery by October 11th, when this additional discovery period closes. So they got to meet by October 11th. The discovery does not mean it has to be complete by October 11th. Then you go further down. By October 18th, each side must file in one document a trial brief explaining its position on the legal and factual issues in the case. Boy, oh boy, that is pretty quick. The date of this recording on October 8th, that's pretty quick. That's less than 10 days. So, and even on the date of this order, October 4th, that's not much time. That's 14 days, 2 weeks, including the weekend. Okay. So everything's happening very, very fast. Most trials take a long time, take a heck of a long time. So, but it's quite interesting these days. So let's continue further. Okay. Among other things for October 18th. Okay. Including like any motion for summary judgment, which I'm sure could occur. And certain court orders, they want to make sure that this filing brief does not exceed 70 pages, because knowing lawyers, we definitely could exceed 70 pages on this kind of issue. Okay, by October 25th, each side's response to the other side's combined trial brief must be filed in a single document, not to exceed 70 pages. It's basically a reply brief. Okay, that each side gets that opportunity. And then another relevant date, any other documents, essentially exhibits, witness list, notice of requesting more time for presentation of evidence, those are due November 1st. So again, a lot of things are happening very fast. Some of you may have seen this other date when the trial is going to happen, and that is October 5th. That sounds like a familiar date, doesn't it? Well, it's actually the date of the election. The election day is the first Tuesday after the first Monday of November. Okay. So that's November 5th. It shows it here. The next presidential election will be November 5th. So I don't know. Is it just by chance? What do you think? Let me know in the comments what you think about that. It's just strange that they picked November 5th, but hey, don't worry. If you're wondering if America recognizes Election Day as a holiday, they surely don't for some odd reason. It's not here on the court schedule, because I'm sure some of you may be thinking like, well, is the trial still going to happen on that day? I don't think. If you're wondering my JT's prediction on this, on if this case will be rescheduled, I don't think so. Okay. I think the dates that are set forth in this order by district court will continue. Um, and so every party's got to comply with those dates. Okay. Because I know a lot of y'all don't want this to like just fester and just get continued delayed. I know some of you think um, that because this trial is falling on election day, that somehow they could delay it. And they could, just because the trial is going to happen as scheduled. Now, many lawyers know that just because it's scheduled for November 5th doesn't actually mean that trial will continue on that day. Now, when there's a docket call, there could be a couple other cases on the list. Essentially, we call it a docket, like the schedule. So things can happen. Maybe even the judge will say, "Well, let's just reschedule it on their own, whatever they want in that sense, however they want to do it." Maybe both parties will say, "Well, let's just reschedule it." I don't think the parties will agree to that. Okay, because I'm sure both parties want to just get it done. All right. I would hope the Democratic Party wants to do that. Just an overview here. If you are still wondering what the heck I'm talking about, you've been living under a rock about this. This lawsuit, parole in place lawsuit, was first announced in June. and it's a lawsuit filed by 16 Republican states to stop this program, claiming it's unconstitutional. We have more information for you, so because especially if you haven't watched a prior video about this, now essentially a bit more context here. Now, the same day the lawsuit was filed, the suing states also filed a motion requesting that Judge Barker set a preliminary block against this keeping families together process. Okay, the PIP. All right, so that while this case proceeds to final judgment that we just got to order on October 4th. Now, in the meantime, it's important to note that, of course, that based on a lawsuit by the 11, not lawsuit, the motion to intervene by those 11 families, unfortunately, it resulted in them not being included. Okay. And I actually think, there's my JT thoughts on this, that they should have been included because it would have been more impactful to show that this PIP program, Pro in Place program for married folks, is a constitutional program. It affects a lot of people positively so that they don't have to leave the United States. All right. So I am curious. I may even do more research for y'all, legal research to see what other scenarios where other parties were excluded or included when they filed a motion to intervene. So stay tuned for that. That'd be quite interesting. But of course, it just it's just a bit strange that so quickly George Barker from the Eastern District of Texas, within a few hours, was signed a new order. Okay, signed a new order to have this essentially a scheduling order ready to go. Okay, now it doesn't have this timestamp here, um, but based on information that was shared with me, that this is pretty quick. So if you're ever curious about if this is going to take a long time, I believe again the schedule will continue, stay in place in that sense. But don't be surprised if this Judge Campbell Barker could delay the actual order. Okay, and so by the fact that it's happening on election day, maybe they're trying to keep it out of the political limelight in that sense that they don't want this to be affecting people's decisions on election day. Let me know what you think in the comments. Okay. So that wraps it up for this video. Now, I do want to share. Again, I mentioned earlier that USCIS still can accept applications here for the Pro in place, but cannot actually approve them during this time. Okay. And that was mentioned in the Eastern District of Texas order from October 4th. Okay. Now, the alternate strategy. Okay, if you're ever wondering, what could you do in the meantime? Now, it's October 8th at the time of this recording, all right? But if for some reason the trial order is delayed and delayed, there's nothing stopping you from filing a petition. Now, it depends on your scenario. Maybe some of you already have the petition filed, maybe you already have it approved. And if you have approved, then the alternate situation is to file the family unity waiver, the 601A. Okay. And the reason being is because the petition by itself can take average 8 to 12 months based on our experience, just by itself. Okay. Not filed with anything else. If it's a 601A, the USS processing times, unfortunately, are at least 36 months. So 3 years. Some of our clients that we filed about 3 years ago are just now getting approved this past year, 2024. Okay. So it seems to still hold true that it will take at least 3 years. And I don't find that that will be reduced anytime soon, unfortunately. So keep that in mind because, but we'll keep our fingers crossed that that order will actually come out very soon after the trial and not be delayed. Now, of course, I can't end this video without sharing some success stories. So we have a couple here I'd like to share with you that we got their case done. We got secured their legal status in a timely manner and maybe even faster than some of the clients thought. So we're very fortunate. I am very fortunate about my team helping these clients in a timely manner to secure their legal status. So if you're in a situation that whether you have a lawyer or not, and you're just not getting the service you want and that you deserve, maybe because we receive a lot of inquiries that people say, I hired someone, but they haven't filed my case. Now, look, if you just recently hired someone, let's look at the facts on that, right? But several people have contacted us over the few several weeks. We received this unfortunate situation where people have said we paid a deposit, we paid X dollars, and it's been many months. Okay, it's very unfortunate here. I'm not here. I know we have lawyers watching the channel as well. I'm not here to step on anyone's toes. Okay, but y'all know there are some really bad apples out there. So don't think that's normal. Okay, if you're interested to learn more about how we do things, please read our Google reviews. We have at the time of this recording, at least over 350 five-star reviews between several locations on Google. Okay. If you're interested in our services, click the link below, click option number 1 so you can learn more how we secure your legal status. If you want to just speak directly with an attorney, that is a 3-digit fee. That is option number 2 in the link below. If you're not sure which visa type you're eligible for, maybe you don't have a company sponsor you, you certainly may not have a family relative that can sponsor you, then that's option number 3 in the link. So you can have the opportunity to learn more. And that's free. That's completely free. Those webinars are on a rolling basis. So keep your eyes peeled on your email box whenever we send you an email about the topic you're interested in. Okay. All right. We appreciate you. Thank you so much. And we'll see you on the next one.